Well, thank you, panelists. That was very interesting and thoughtful. I'm sure everybody agrees. I thought I would start by returning to something that Professor Prakash raised earlier in addressing, which is, it seems to me, a question that originalists have to answer, and goes to the heart of the question posed for this panel, which is, why don't we see more originalists who are not regarded as politically conservative on the bench or elsewhere? And I wondered if Professor Fallon or if Professor Whittington wanted to address that point.
My own sense about this is, as I said, that there's virtually nobody who doesn't think that the way that constitutional language was originally intended or understood doesn't have a significant role in constitutional interpretation. I think it's also the case that apart from the theory that courts should be deferential, the rule of clear mistake, that there really was no constitutional theory as people now talk about it, rules for how to interpret the Constitution, before the originalist movement in the 1970s and the 1980s. And when the originalist movement was a self-conscious movement, is in many ways the first constitutional theory on the block in the 1970s and 1980s. Again, if you don't count deference and clear mistake as a constitutional theory, then the originalists were the ones who were there first. The conservatives were the ones who were there first. And it's no accident that conservatives wanted it in the 1970s and 1980s, because it was at that point a fighting faith, not just to stop more liberal developments in constitutional law, but to roll back a good deal of what had been done by the Warren Court, and to some extent what had been done by the court in the aftermath of the New Deal, on the ground that it's not consistent with their original understanding. It's also the time when, as Marianne alludes to, Roe against Wade was on the national agenda, and it was something that many liberals were committed to and knew that they couldn't defend by reference to the original understanding. It's a time when gender equality was very much on the national agenda, and liberals were very much aware that they couldn't defend that by reference to the original understanding. So to some extent, conservatives got there first, and I think looking at how conservatives have got there first, liberals also said to themselves, or many of them, I couldn't be honest and try to nail myself to the mast in some significant way, that I'm going to do what is consistent with the original understanding in every case. So I think part of it was the original valence, originally understood valence of originalism. Part of it was just intellectual honesty. And part of it was that the way our constitutional law had developed, the first generation of Originalists 1.0, could have as much revolutionary bite and fervor as they wanted, but with respect to nearly every other matter where being an originalist would put one in the camp of being a nut, then originalists of that 1.0 generation could say, well, we've got an exception for stare decisis. And I think as a result of this will be impolitic, but I believe it. I think to some extent as a result of liberals' intellectual honesty and not wanting to say we're originalists too, originalists of the conservative stripe were able to gain what looked like the political high ground, because I think, as Keith says, it's nearly everybody's intuition before realizing what the practical consequences would be to think that we should all be originalists. So I think originalists, conservatives, acquired the political high ground with respect to originalism, and I don't think the effort to maintain that political high ground has been consistently honest in every case, given the exceptions and the manipulations that some originalists are willing to tolerate in their applications of their theories to get to the results that they want to get to.
Thanks. Let me ask Professor Whittington to follow up, and also maybe to address the question of who is an originalist. You know, what makes an originalist to begin with? Is Justice Souter, is he being a great originalist when he engages Justice Scalia in the debate in the meaning of the Free Exercise Clause? Because I think I agree with Professor Fallon, at some level everyone agrees that history has to be part of it. But where do you cross the threshold to become an originalist? And if you want to sort of add to what Professor Fallon said on why there aren't more originalists who are not regarded as conservatives.
Well, I think as time has gone on, there have been more sort of liberal scholars in particular who've been willing to take originalism more seriously, and some who've embraced originalism as a theory, in part as the Reagan years have become more distant, and so it sort of seems more plausible to sort of put those debates behind you and then start thinking about, well, maybe originalism isn't just for conservatives, maybe it's possible to think in terms of a possibility of a liberal originalism, and can you embrace that theory? I think some of the doubts that still remain, in particular for a lot of liberal scholars and also liberal judges and liberal politicians and activists, are exactly these kinds of doubts, though. Are there sort of really crucial exceptions that a originalist theory is not going to be able to reconcile itself to, whether it's Brown v. Board or Roe v. Wade or other cases where at the end of the day you want to make exceptions for. And are those exceptions so important that you're willing to sacrifice a theory that at other levels seem intuitively plausible, and you want to say, well, there's lots of reasons to think that, well, sure, originalism seems right, you surely ought to generally follow the text as written and as originally understood. And there's lots of circumstances in which that's true, but there's also going to be circumstances in which that got to be sacrificed. And I think that at the end of the day, there's a lot of liberals who are going to get off the car there. But there are some who are working out theories in which they want to say, well, look, I can figure out a way in which I can get those results and reconcile myself to it. And so Jack Balkin is an example of that, and Keil Amar is an example of that. And so I think once you see some scholars moving in that direction, I wouldn't be surprised if later, probably, you don't wind up seeing some judges and other sort of more public figures who sort of visibly, on the left, who visibly embrace originalism as well.
Could I just say, I've talked a long time, but I hope that there won't be a liberal originalism. And I hope that there won't be a liberal originalism, because it seems to me that's exactly what scholars and judges ought not to be doing, which is to say, I'm going to be an originalist because I know it's politically popular and it resonates with the American people, but I'm going to find some way to do my originalism so that it comes out with liberal results. And I think that there is some of that squirming that Keith is talking about going on among conservatives, so that they can be originalist and oppose affirmative action, although nobody thinks that affirmative action would have been inconsistent with the original understanding of the Fifth Amendment and probably the 14th Amendment too. If conservatives want to find some way to be conservative originalists, good for them. I hope liberals won't fall into the same trap.
Well, maybe liberals can just do it right.
I'd like to echo what Keith said. I think, and you know, Professor Fallon, your hope is misplaced. It's already happening. Originalism is a big tent, and people, I think, gravitate to the notion that the meaning of something is fixed at the time that it's uttered or written, and that it doesn't just change over time. There seems to be two different questions that originalists often conflate. One is what something means, and two, what do we do with it? So, you know, we can find out what the Articles of Confederation means, but it's probably not going to have any effect because no one really seems to care about the Articles of Confederation except for academics, and that's fine. I'm not lamenting that fact. You can understand what the original Constitution means, but you don't need to be committed to it just because you're an originalist. Bruce Ackerman is an originalist, but he thinks that the original Constitution plus its amendments have been amended in various ways by constitutional transformations. he can have that view and still be an originalist, because originalism, I don't think, tells you what the content of the Constitution is, nor does it tell you what the fundamental document of the United States ought to be, what fundamental law ought to be. You can have a totally different theory of that. Some strands of originalism try to make a claim for why the original Constitution plus its amendments as originally understood ought to be our fundamental law, but that's separate from the claim of what something means. And I think at bottom, originalism is a claim about what something means. And so if I can speak for the nuts out there, it may very well be that the original Constitution doesn't permit Social Security and doesn't give women equal rights and wouldn't give me the right to be up here as a matter of federal constitutional law either. So much the worse for the original Constitution, so much more why we might want to amend it or read the Constitution as containing various things that aren't in the text of the original Constitution. But that's a separate discussion from what something means. And I think too often what goes on is the claim is if you can't justify, if you can't find within the Constitution certain provisions that we all think ought to be there, then you've made a mistake about what the Constitution means. The meaning of the Constitution or anything can't be derived by the results. My daughter might wish to believe that go to your room means go have some chocolate, but that's not what it means. And so I just find it problematic that people think that the Constitution has to mean certain things merely because we have come to believe that certain rights ought to be given to certain people. And I certainly support Professor Case's right to be up here, as I support my own, but I don't think it follows that the Constitution necessarily has to constitutionalize that just because we think it's an important right to have.